I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of
And we are back, and we are back. Thank you for watching. Go ahead and hit that like button, y'all. Hit the like button right now. Do your boy a favor. And you know what? If you're watching this during the first day that this video is released, which today is Sunday, November 24th, if you're watching this video today, you should go to the description. Come on over. We are on a 48-hour live stream. We are approximately 24 hours in to a 48-hour live stream. Tomorrow, we're going to get closing arguments. So we're going to go right up till court. Well, I guess we're going to be probably still live streaming even once the closing arguments start. So probably going to go over 48 hours. But anyway, go down into the description. Come on over to the other channel, which is Morbid Law Stories, and subscribe and join the live stream. Y'all, today what this video is about is, you know, Yak Gotti, he had this interrogation tape. It dropped the other day. Everybody got into an uproar about it. I think, you know, different people, you know who the usual suspects are. They dropped this tape, and maybe they were trying to embarrass him. I don't really know what the point of it was. But I think one of the theories that I've heard is that the state is trying to damage his reputation. See, Yak, he just beat the state, y'all. He just beat the state because he had 3 of his charges effectively dismissed under directed verdict. Now, I did a video about this before, but I didn't put it all together so you can see exactly what happened while cutting out all of the other different things that were going on in court at that time. So what I'm doing now is I'm putting together one video that shows exactly what happened when Yak Gotti got his directed verdict. And I think that is probably the reason why we see this video drop now. Now, it's conspiracy theory a little bit, but it does kind of make sense, right? They want to damage his reputation. Look, you got us. We're going to try to get you. I don't know if that's what happened, but that's a theory out there, and it kind of makes sense to me. So I'm going to show you exactly how Yak beat the state this week, and a reason why perhaps some people think the state might have tried to get him back, try to get a little get back. Other than that, y'all, we're going to get right into it. Don't forget to come join our 48-hour live stream with the link in the description. Don't forget to comment, like, subscribe, and let's get into it.
Good morning, Your Honor.
Good morning.
Let me begin just by stating that Mr. Shart and I last night went through Good morning, Your Honor.
Good morning.
Let me begin just by stating that Mr. Shart and I last night went through a number of the predicate acts and overt acts that are in the indictment, and we've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial.
Okay.
And I'm going to let Mr. Shart speak to that when he makes his motion orally this morning. I join in all of those that he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision. As to, just turning to the details of the different counts, as to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury. And that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they've stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they've stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they've presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although, again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house. Even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there is an essential element of 133 that has been left out. So I believe a directed verdict on 133 would be, on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one the one specific case that I saw that would support Mr. Abade's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abade's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay.
Which,
Before you do the gang counts,
Yes.
can you address the 58 through 61 drugs and machine gun, and whether there's evidence of constructive possession for Mr. Kendrick?
yes, Your Honor. So first with the possession of machine gun, which is count
62,
62.
yes, sorry.
One, just the proof that of the gun itself, we have the.
I know that that's established.
Okay, so as regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba, that he fled from the home
No, he was, okay.
and apprehended, Your Honor, and we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor. We believe that inside of the home, there were a number of guns, both from the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found?
The machine gun is actually downstairs, we believe, in the basement of the home by underneath
Laying
the
on the
couch.
floor?
Yes, laying on
Yeah,
the floor underneath the couch, Your Honor. It is the state's theory, Your Honor, that when the SWAT team did not make a quiet announcement to get to come into the home, and it is the state's theory that when the announcement was made, you could tell from some of the images, we believe that there was an effort to hide some of the items that were inside of the home. This gun was kind of maybe kicked underneath the couch where you had to pull it looks like they pulled the couch back in order to observe this gun that was actually in the basement, Your Honor. To address the drugs, Your Honor, which are counts 58 through 60, which is the possession of marijuana with intent to distribute, the possession of codeine, and the possession of cocaine, Your Honor. I believe all of these items, which was Stacy Exhibit 12XX, 17XX, and 18XX, the marijuana, I believe, was out in the open. If my memory serves me correct, I need to pull up the picture again, but I believe that the marijuana was out, present, and open in the home, Your Honor. That specifically 18XX was not hidden. 17XX was the marijuana with guns. That was found in a cabinet, I believe, above the refrigerator inside of the kitchen of the home. And then the codeine, if you give me a moment, I just want to pull up the picture so I can make sure I know where the codeine was found
They
inside.
were like in a box in a closet, right?
I believe they were, but I thought there was some that was out as well. But course indulgence. Yes, Your Honor, the codeine was found in the closet and then in the bathroom upstairs in the house. And then the cocaine was found In the pantry as well. In that same bag, there was a bag that had in the pantry that had the cocaine and the cocaine and the codeine, Your Honor.
And the marijuana was out where, in the kitchen?
So there's one in a Tupperware container that's in the on the kitchen counter, and then there's the bag of marijuana that was in that cabinet with the gun.
Right.
That's in the cabinet above I think the refrigerator.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor. The evidence that we have is that he was present that day, and we believe that he had been present maybe a few days before as well.
But not continuously?
Not continuously, no, Your Honor.
And so can you address constructive possession?
Your Honor, it's just the state's position that at the time of Mr. Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with a machine gun, right?
He's charged with the machine gun, and he's charged with possession of a firearm during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged both.
That's the count.
That's-
Which count is that?
Yes, Your Honor.
That's count 63.
Yeah, so count 62 is the machine gun, and count 63 is possession of firearm by convicted felon for the other, in addition to the machine gun, the other guns found inside.
Where are all of those found? Remind me if you don't mind.
Yeah, they're found in different locations. So I believe the FNH57, so 13XX, Your Honor, is the FNH57, and that's found on the kitchen counter behind like a green dinosaur. And then there's the two firearms.
Can you
which is-
show me a picture of that?
Sure.
Let me join Zoom.
So, Your Honor, this is, I believe, the FNH57, I think it's 57. And that's in the living room area.
All right, those are just sitting out on the counter, right?
Yes.
All right.
And then
That's in the cabinet.
That's the-
That's above, yeah.
yes, Your Honor,
So a lot of this looks like it's documenting what the guns are. I just want to see the ones that show where they were found.
so these are two more.
Those are in the cabinet.
Those are in the cabinet.
Up above, yeah.
This is the pantry, Your Honor, where this other gun was found.
That's like the, I think somebody referred to it as like the hidden
Yes. It's
door or something like that.
Yes, Your Honor.
And that's where the codeine's found too?
Yes, Your Honor.
And the cocaine?
Yes.
Okay.
And then this is where the machine gun is found, Your Honor.
That's after the couch is moved or after it's,
Yes, Your Honor.
any idea where, do we have a picture of the couch before it was moved?
No, I don't think so, Your Honor. I think once they moved it and found it, they took a picture of it.
Okay. All right, thanks.
You're welcome.
All right, and then you were going to circle back to,
Your Honor, I guess there's one more gun to be shown.
okay.
And there's one found in the upstairs bedroom.
Whose bedroom is that?
We believe this is, the room. We think that the ID for Jimmy Winfrey was found in this room.
For who?
Jimmy Winfrey was found
Okay.
in this room.
All right.
Go back to the gang count, Your Honor?
Yes.
Okay.
And address Mr. Kendrick's count first, which is 57.
Your Honor, it's the state's position, Your Honor, that the drugs inside of the home were all, specifically the codeine, Your Honor, as well as the marijuana with the phone counters were being prepared for distribution. If you remember, there was the large pail of codeine that was found, a number of different bottles being found, Your Honor. As you also saw, although not charged because it's not illegal, was the YSL drink juice that was inside of the home, Your Honor, which looked like that was being packaged for some type of sale or distribution of itself, Your Honor, that these particular drugs were possessed in furtherance of the criminal street gang to sell narcotics, Your Honor, to sell both marijuana as well as to sell the codeine. We have evidence of the money counter inside of the home, Your Honor. Mr. Kendrick was at the home, was present at the home. There are a number of different guns present inside of the home, which we know guns are usually kept with drugs in the sale of drugs, Your Honor. And so based on that evidence, we believe that there's sufficient evidence to go back to the jury to show, at least for that count, participation in criminal street gang activity, given that evidence that has been admitted into evidence, Your Honor.
We didn't have any evidence as to like the weight of the cocaine or anything like that, did we?
Yes, I believe the GBI did.
Okay, maybe y'all just didn't highlight that.
Yes.
But that wasn't a.
That's not an intent
That
to
wasn't a
distribute.
distribution
No,
amount.
no,
Okay, right.
that's simple
All right.
possession. And Your Honor, it's specifically regarding the guns, because we also charged count 57 with the guns. The state believes that they were still in the midst of a gang war. This was only 2 months after both Mr. McMiller and Mr. Ford had been murdered. There had now been the retaliatory shooting of Mr. Shamel Drinks. We know that 2830 Waters Road had been shot at multiple times. And so we are now still in the midst of, or we believe, a gang war. And with that amount of guns and weapons inside of the home, a machine gun, Your Honor, that these were tools, whether it was to protect themselves or get ready to go and continue war, that they had this ample amount of firearms inside of the home, all in furtherance of this gang war that we believe is still going on even to this day, Your Honor.
Okay. All right, moving on to Mr. Stillwell's other counts.
Yes, I believe Mr. Stillwell's count that I have not addressed yet are participation in gang activity, which I believe
Yeah, save that one to last. Let's talk about the underlying ones first.
Okay.
If you don't mind.
So I believe his next counter is possession of a firearm by a convicted felon. And possession of a firearm during the commission of a felony, Your Honor. I believe those are the last two.
Okay, hang on then.
And I will address the possession of a firearm during the commission of a felony, and then Mr. Abati will address the 133 possession of a firearm by a convicted felon.
First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution. And doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged? So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. So let me just do it this way. I am denying the motion for directed verdict on all counts except I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to evaluate it as though the jury is going to believe